Thank you for taking the time to visit the Youth Business Exchange YouTube channel. We truly believe that the future of entrepreneurship is youth. Before you go, please like this video and subscribe to our channel. We look forward to seeing you again. Peace. Good evening. This is Kerwin Phillip with the Youth Business Exchange, and I would like to introduce our guest speaker for this evening. Attorney Marlene Johnson is a managing attorney of the law office of Marlene A. Johnson. She attended Morgan State University and the University of Baltimore School of Law, receiving her bachelor's degree in economics and Juris Doctor degree, respectively. She began her career as a staff attorney with the Legal Aid Bureau, in which she represented the underprivileged in Baltimore City in various administrative law matters. In 2000, Marlene Johnson established the law office of Marlene A. Johnson Professional Corporation. Since its establishment, she has served individual and corporate clients across the country in a variety of legal and business matters. Attorney Johnson is known by her peers as a dedicated advocate, a caring mentor, and an innovative businesswoman. In 2000, Attorney Johnson was celebrated for her accomplishments by Career Magazine as one of its top 40 under 40. So at this point in time, I would like to introduce Attorney Marlene A. Johnson.
Part of your brand. So we're going to talk about the three primary ways that you can, before you can actually protect it, you have to develop it. So we're going to talk about once you've developed your brand, or as you develop your brand, or the components to your brand, how can you make sure that you keep it? I don't know if maybe you may remember being in the schoolyard and you would have some candy and somebody would come through and they would say, knock it out your hand, and say, you ain't want that. And it would fall on the floor and you would lose it. And of course, unless you subscribe to the 5-second rule, you know, your candy or your cookie or your treat is gone. So this is kind of what we're going to be talking about today. The stuff that is yours for your business, which is the substance of your business. How do you make sure nobody comes out of nowhere and just knocks it out your hand, or takes it and tries to use it? You probably may have in school had somebody who wanted to cheat off your paper and get your answers, and you may be writing a test, and you want to protect it and make sure your answers are your answers to put before the teacher. So this is what we're going to talk about today: how to protect your business, how to protect your cupcakes, your logo, your t-shirts, all of that, your design, your invention, all of those things we're going to talk about today. So I think that by way of introductions, I'm going to have to tie Mr. Kerwin down and take him with me wherever I go, because he did such a great job in introducing me. At one point, I was like, who is he talking about? Oh, that's me. So thank you so much. I have been practicing now for 20 years. And during that time, I've done a lot of things. One of the things that I love to do is I love to work with small businesses and entrepreneurs to help them maximize their growth potential. So let's jump right into what we're going to be talking about today. So at some point in your business, there are three types of intellectual property that you may want to protect. The first is copyrights. The second is trademarks. And the third are patents. Most business owners should come in contact with copyrights and trademarks during the course of your business. Some people may also come in contact or have a need for patents. So we're going to talk about that, but not everybody will need a patent. Most people will need a copyright or a trademark. So let's start with copyright. So copyright really is a form of protection that's provided to authors, or the people that make what they call original works of authorship, meaning something that you have written or created in some type of literary, dramatic, music, artistical, or other forms that you want to disseminate to the public. So you may say, well, I'm a baker. I don't need a copyright. But yes, you do. You may want to have, or you should have, all of your materials, all of your marketing materials, your brochures, your maybe you're talking about what your baking process is, the history of your business. A lot of the things that go on your website, you should have copy written. The reason for that is particularly when it gets to a lot of times on websites where it talks about, and usually on the about page, or you talk about your business philosophy, you talk about your business processes. All of these are things that you want to protect. You want to make sure you protect them in that writing. So it's not protecting the process itself, but it's protecting your writing about the process. If you are a poet, or you are a songwriter, or a producer, things like that, you always want to get those things copywritten so that you can protect what you have written. So you want to make sure that you, before you give it to the public, before you release it in the public, you want to make sure you get the copyright. Now, when do you need to get a copyright? Anytime you have a unique and or original arrangements of words or music that you don't want anyone else to use. I'll give you a perfect example. For me as a lawyer, my templates for my some provisions in my contracts, I copyright. My information when I do these types of, and I did make one mistake, I made a foolish mistake today. Normally, you will see in the bottom corner, in one of the bottom corners, I will always put the copyright symbol to say this particular presentation is copywritten. So this I own. No one else can present it in this way. Now, if somebody wants to do a different presentation on the same subject matter, they can create their own, but this one is mine. And so that's why you want to have your things copywritten. Some of the things you cannot copyright. You can't copyright facts. You can't copyright ideas. You can't copyright systems or methods of operation. Now, how do you get a copyright? So there are two ways to get it. Both of them are kind of considered to be valid, but we prefer the second one over the first one. The first one is what we call a poor man's copyright. And what a poor man's copyright does is it helps you to tell others when you produced or published a work. So a poor man's copyright is really, really simple. All you do is take whatever your written material is, and let's say I wrote a poem. I wrote a poem about this pandemic, about COVID-19. And I want to make sure that it's copywritten, and I can't get to the copyright office, or I can't go online and file the copyright. I can do what's called a poor man's copyright. And all that is taking my poem that I wrote, folding it up, putting it in an envelope, getting it postmarked, and putting it in the mail and sending it back to myself. That's a poor man's copyright. The flaw in the poor man's copyright, and it's not technically recognized by statute or by the Copyright Office, but it is recognized because that date stamp on the postmark, now you have to keep it, but that date stamp on that postmark tells you the date. I did it today. And it will show the world, as long as I don't lose it, which is why it is not the best option to have. But as long as I keep it, I can show to others that that I have copywritten it on this day. I think today is April the 5th. So on this day, April 5th, I postmarked it and sent it to myself. So I know it was created no later than April 5th. So if someone comes up with the same poem on October 5th, and I have my postmark from April the 5th, then I show that I was the original writer of that poem. The problem with the poor man's copyright is you always have to keep that envelope, and you have to make sure that the postmark does not fade, does not get ripped, you don't lose it. because the moment you don't have that proof, you no longer have that copyright protection or information that the court can use to determine that you are the original author. Now, the more preferred way to go about getting your copyright is to file an application with the U.S. Copyright Office. That's under the Library of Congress. The reason you want to do it is because they safe keep your information for you. So it will go ahead and be recorded once you file and you pay the application fee, which I believe is $45. Let me see. I made sure that I printed it out. I think it's $45 per registration. Yeah, $45. And it establishes not only the date of the work, but what the work is. And so that way you can go ahead and show to the world, because it keeps it in a database, that on April 5th, I went ahead and I created this poem. Now, in the context of your business, you may say, I'm not a poet or anything like that. But what this does is it helps you to keep your marketing materials, to keep your processes, to keep your history for your company in a way that is protected, that no one else can use without your permission. I know that one of the young people that's on our call today, she's a baker. And so she may want to write out some recipes. Your recipes should be copywritten. In addition to that, the description about the baked goods, and I'm hungry now, so I'm thinking about all the baked goods she just told me about, the cinnamon rolls and the cakes and the pies. But you may have a certain way that you present your apple pie or your apple cobbler. You know, you may talk about the streusel and the caramel and the brown sugar and the buttery crust. The way you describe your apple pie should be copywritten so that no one else can describe it the same way. Likewise, you may have your menu of all of the different types of treats that you have, and that is copywritten, as long as you send it in. And so those are the types of things that we have for copyright. Now, copyright is not only should you file for it, but also on all of the materials, you want to include this copyright language, okay? Now, you'll see initially, and I don't know if you can see my little mouse here, but you'll see it says copyright, and then it's a C in the circle. The C in the circle is the indication that something is copywritten. So you always want to make sure, if you're doing a brochure or on your website, that you put that somewhere on each page of your materials for the website. If you're doing a brochure, you can put it in one place. I normally, if I'm doing a brochure, I'll put it on both sides. If you're doing a book, you can just put it at the beginning. That's fine. But you want to put the C in the circle, the year, and who owns the copyright. Now, this becomes important because if it is that you have hired someone else to do something for you, you need to make sure that the agreement is for your business that you own the material. And that becomes important because a lot of times we don't do everything ourselves. You may hire a graphic designer or a copywriter or a someone to prepare your materials for you. You want to make sure that your materials, you own the copyright, even though they did it. And even, and if you don't, there is a chance that they can say, oh, well, that's my work. I just allowed you to use it. So you want to make sure whenever you get into any contracts with anybody to do anything for your business, that not only the copyrights, but any material that is created as a result of you hiring that person, that you own it. Now, you can make the decision about whether or not you're going to own it individually or your business is going to own it. And that's something that you should talk to your client. You should talk with your attorney about. Now you'll see here, it says by Bill E. Elliott. In this instance, Bill E. Elliott owns the copyright. However, it could say by Tati's Treats Bakery. And that would be that the bakery or the business itself owns the copyright. So you want to have that discussion with your attorney about whether or not you should own the copyright or your business should own the copyright. And then if you're writing a whole book or something like that, you want to make sure you add this this additional language: all rights reserved, no part of this book or publication, you can say, or writing may be reproduced or used in any manner without written permission or of the copyright owner, except for the use of the quotations in the book review. All right, so we talked about copyrights. So again, copyrights only have to deal with written material, so words and music, things like that. All right. When we get into trademarks, trademarks really are used to protect the physical depiction of things. So words, name, symbol, device, or combination of any of those, if you use it for your business, you want a trademark to protect it. Now, let's talk a little bit more about, I'm sorry, I'm going in the wrong direction here. So trademarks, again, is different from copyrights because the copyright covers what actually is written. So it covers the words, the way you string the words together, the way you string the musical notes together. The trademark covers how it is visually depicted. So you see here, these are 1, 2, 3, 4 copies of different types of trademarks that most of us have seen. And the reason we know it's a trademarked item is because you see here the little R, or you see here the little TM. Those indicate that there is some type of trade or service mark for this particular visual representation. We know that this is Nintendo, and we have associated it with Nintendo video games, correct? So we know when we see this symbol, we know that in our mind clicks that that's Nintendo video games. When we see this, we know that's Coca-Cola soda and Coca-Cola products. And so it really is, for trademarks, you're registering some type of logo, some type of original image, or some type of slogan. It could be pictures, it could be words, it could be drawings, markings, anything like that, but it needs to be something that is original and can't be confused with anyone else or anything else. So you can't just say, I'm going to trademark the word what, because what is commonly used in the English language. But if you have something, I think it was Ray Charles that used to say, I'm gonna make it do what it do. You may be, and if he had that in writing, in some type of visual depiction, he may be able to trademark that. Now, trademarks are a little bit more difficult because you have to do a couple of things. You have to, one, determine if your image should be trademarked. Not every image can be trademarked. So if I wanted to put for my logo, I wanted to trademark my logo, I could trademark my logo as long as it's something that clearly identifies only my business or service. If I just put an elephant with no markings or anything, I probably wouldn't get approved for a trademark for that. But if I put an elephant with the scales of justice in it and maybe an M and a J, so that it's very clear that it's Marlene Johnson's representation or Marlene Johnson's logo, then yes, that could be used as a trademark. Now, not only do you have to research if your image could be or should be trademarked, but you also have to identify what category or what class it should be trademarked. With a copyright, the work is just copywritten. The whole thing is just there, one copyright. But when we talk about trademarks, you have to you have to obtain a trademark for every class or every category in which you're going to use the trademark or use the logo. Let's use the logo, for example. So I'll give you an example. If I'm in, as I have been in the natural hair care business now because of this pandemic, and I can't get to my hairdresser. So now I have to start putting together concoctions or whatever to try to work or do my hair. So I say, oh, okay, well, I can get into this hair care business and I want to call it Marlene's Hair Care. If I say, okay, well, I want to put a logo for Marlene's Hair Care, if I want to buy some brushes and put my logo on some brushes, that would be one particular class. So that would be class 21. If I also want to get like a little, one of those little bags that you use to put all your toiletries in, a toiletry bag that I take with me when I travel, not only would I have to submit the application for class 21 for that logo, but I also would have to submit class 18. If I then want to put it on stationery so I can put it on my letterhead, then and that be protected, then I would have to also do class 16. So this is where it gets complicated. Whereas a copyright is once you submit it, it covers every which kind of way the poem could appear. You have to think about whatever your image is and determine how you're going to use it. So if you want to do merch, you want to do t-shirts, that's one category. You want to do bags, that's another category. You want to do sneakers, that may be another category that you want to use. So you want to know in advance, how do I go back? Sorry guys, operator error. So you want to make sure that you know, because you want to make sure that you're adequately covered. So going back to that original scenario of Marlene's hair care products, if I submit an application for it to be on brushes and combs and carry bags, but then I don't put it on t-shirts, someone else could go and own the trademark to put it on t-shirts, and there's nothing I could do about it. So trademarks can sometimes be expensive because the standard fee for one trademark is between $225 and $275 per class. So going back to the instance that we talked about 4 different classes. So you're going to have to take the $225 and multiply that by 4, and that's what you have to pay to the Office of Trademark and Patents. And so a lot of times what people will do is they'll just trademark one category at a time. And whereas you got to do what your money allows you to do, but that sometimes leaves you unprotected. So once you know the categories that you want to do, then you set up an account because now this stuff is preferred to be done online. And you have to set up an account with the Office of the United States Office of Patent and Trademarks. And then from there, you can file an application. Now, technically, you can do the application yourself, as with the Copyright Office. However, the problem is if you don't do it correctly, cover the right categories, and do everything right, you won't have the protection. So unless you really are able to do it, sometimes your parents can help you do it. But it may be beneficial to get you an attorney to help you do this as well. Now, I did include here, and I'm going to send to Kerwin so that he can provide it. I did include a link to the trademark office's, like a little fact video, which is really good and helpful to help you understand trademarks. Now, the last type of intellectual property that I want to talk about, and I will admit that I am not completely versed in patents because I'm not a patent attorney, but I know enough to help explain to you what it is. But you need to be specially barred to practice patents. And I don't do that because it's a little bit more scientific in nature, and that's just not where my interests are. But it becomes important because a lot of things may be patent worthy that you do, and you want to make sure that you are protected. So a patent really is meant to protect an invention, and it's used to, something you create, it's used to protect that. As an inventor, you create something. Now, there are three types of patents. You can have a utility patent, and usually utility patents are meant or reserved for someone who invents or discovers any new or useful process, a machine, some type of article of manufacture, a composition of a matter, or a new and useful improvement of something that already existed. So you may have a certain way that you go about doing things that when you do it that way, it is useful to the public and nobody else has ever done it that way. You may have, like here, I showed, actually this is a design patent, but you may have some type of article of manufacturing, some type of something that you can produce in a certain way that other people cannot produce. So this is all about processes and machinery and things like that. So if it is, going back to my friend with Tati's Treats Bakery, because I'm hungry again, so I'm going to really lean on you today, Tati. But if you created a different way to create cupcakes, maybe you created a new tool or implement like that, you would get a patent for that. Not only are there utility patents, but they're design patents. So design is a new design of something. And you'll see in the picture here, this is a copy of a designed patent for a car. So it would be for any type of design that is used in the regular world. And you would get a patent for that. The last patent, which I thought was very interesting, is a category of patents that I think we actually need nowadays as well. It's a plant patent. So if you discover a new variety of plant, then you get a patent for that too. Now, with patents are the only thing that I definitely know that you need an attorney for, just because there's so many nuances. You want to make sure that you have an attorney that is admitted to the patent bar. One thing I want to stress, and it's not only with respect to patents, but I think about it more so here, is that before you talk to anyone about your design, your invention, your logo, any of that, you want them to sign your confidentiality agreement, that they will not use or discuss your design, your invention, your work, your logo with anyone else. And we already talked about, before you hire someone else to do some work for you, you also want to make sure that whatever they produce for you, you then will own. So those are the two things when we talk about intellectual property that you want to make sure that you always do. You want to work also with your attorney to prepare your application. And it looks like I missed the link here, but I will add it and provide it to Curran so that he can upload it. Now, the two resources that are going to help you with this would be the U.S. Patent and Trademark Office, which is its first website. I don't know why it keeps going on me. The first website is the U.S. Patent and Trademark Office. They have a lot of useful materials, and they also have a helpline that you could call and ask questions, as does the Copyright Office. I want to encourage you, I didn't want to overload you with too much information. I kind of just wanted to give you the basics, but I want to encourage you to always think about this. A lot of times people, when we get into business, we're so quick to go ahead and provide the good and service, to sell the cupcakes, to do the design business, whatever it is that we do, that we don't think about protecting it. And then we have to go back and spend a lot of time and money and trying to then enforce our rights. So I hope that I've been able to give you a good overview of the intellectual property process. The thing that I will say most is, before you do anything, think about how you can protect what it is that you're doing. And you want to make sure that when you're in business that you have an attorney or a firm that is ready and willing to help you with these intellectual property issues. Because even if you take the steps that I've suggested today, sometimes people just use your stuff. And then you have to issue cease and desist letters, file lawsuits, and things of that nature. So you want to make sure that as a business owner that you have an attorney that is willing and able to jump in and do the things that you need to get done. Of course, if you ever are in need of legal advice, I'm always here. You can always give me a call. Even though we are currently on lockdown, I have had my calls forwarded, and you can reach me and talk to me about this or any other legal matter that you have. I don't know, Carmen, if we have the ability to open up for questions or how you want to go forward.
Yeah, we could take some questions. Does anyone have any questions? I know I have a couple, but I'll wait until we'll see who if anyone else has anything. 1 second. All right. So does anyone have any questions? Just unmute your mic and ask.
This is Tati's dad on behalf of Tati's Treats. I know it's a little bit of different voice than what you had before.
Sound like Tati.
You done grew up real quick, huh?
Yeah, this lockdown did a lot to people.
But that's still we got Dad here.
Yes, ma'am. Yes, ma'am. Yes, sir. To everybody, I just want to say thank you for holding these events. It's a lot of really good information. Our daughter, we got into business about 2 years ago, kind of as a thing to get her out there and just explore something she was already interested in. So the fact that we have all these resources available is super exciting for us, and it's very, very helpful. I know it's not a question, but I just want to make sure I got that in before the meeting got dispersed.
Okay. Well, thank you. All right. Well, I know I have a question, Marlene. So earlier when you was talking about trademarks, you had the TM at the end of the image. Then you also had the R with the circle around it. What's the difference between those two?
So those are trademarks and service marks. A lot of times people will use the TM more readily for the trademark rather than the service mark.
Okay.
But depending on how you file, they can be used interchangeably.
Okay. Okay. So can you use the same way how you spoke about like a poor man's copyright? Is there also such thing as a poor man's trademark?
No, actually there isn't. I mean, from the perspective that if you've used it and you can prove when you started using it, it may hold up in court, but the poor man's copyright is a little more acceptable than with trademarks. I always say in business, you just don't want to take a chance with your business. So I would prefer that you not use any poor man's version of it. I would prefer that you file. But I have not encountered using the poor man's trademark at all, but the poor man's copyright, yeah. And really the poor man's copyright is really not a thing. It's more so a basis for evidence. So you can substantiate it.
Right. Okay. All right. I think that's all that I have. If anyone else has any questions.
Miss Johnson?
Yes.
This is Tatiana's mom. So thank you again. I do have a question. She created her own logo in a computer art class last year that she has been using. At this point, it's not copyrighted or trademarked or anything like that. It's a very simplistic logo. It's just literally Tati's Treats. And so I was speaking with a coworker who happens to be an attorney as well. And he had mentioned to me something along the lines of a general use copyright. So while we may not be copywriting it at this time, in the future, when she does wish to copyright it, if we have pushback, we can say, in case they say the pushback is, it looks too similar to somebody else's logo, like, I think there's a Tati's Bakery in Florida somewhere. A lady opened a bakery. Her name is Tatiana as well. And so he said, if you would be able to distinguish that your logo is different from hers because it, one, looks different, but two, you have been using it in your area for 2, 5, 10 years, and it's not been an issue, it's been accepted. And so oftentimes they may be able to go ahead and allow you that copyright. Are you familiar with that, or is there a more specific term that we should be looking for?
So in essence, what he's saying, he or she is saying, is that same thing I was saying earlier about the poor man's copyright, that if you establish your usage, it is a basis that the court will consider who had the use of it first. The problem is you run into an issue when it gets later and it's unused, because they could consider that it's just in general use and not reserved for you, which is why I always suggest that you, at the very beginning, go ahead and protect yourself. Because you want to keep the option open for the future. Generally, what happens is you have to go through the process of justifying your ability to use this image exclusively. The problem for that is the issue of money. It will cost you about $225 to $275 now. But to defend something like that 10 years from now may cost you $20,000 or $30,000. And so really it's an issue of money. Now, when she did the logo, and I would have to look at it to be sure, but when she did the logo, it sounds like to me, depending upon what she wants to use it, this would be something that would be better for trademark than copyright. But if she has her menu of services or her menu of products, that may be something that would be copywritten. As opposed to trademark. But her logo would be something that you would trademark. Now, the other issue that you have when you do trademarks and things like that is when you create it, you have to make sure that the creation is original. A lot of times we will use stock photos or photos that we have not licensed and things like that. And we can't get them trademarked because that really belongs to someone else. And so what raised a red flag, and again, I would have to see it to be sure, but what raised a flag is that one, you said she did it in a design class. And so I would want to be able to see it to see if it's something that came from somewhere else. And then that may be a problem for her getting a trademark. But, you know, again, it really boils down to what you can prove and how much money it's going to take you to prove it. So particularly with small businesses, I know a lot of times up front, you're like, I just don't have this $225. But I guarantee you, this is way cheaper than having to defend a copyright, trademark, patent action 5-10 years down the road.
As an add-on to that, how long is that trademark or copyright enforceable? So if I pay that $225, $275 today, is that something that has to be renewed over time? And I apologize if I missed that.
No, I didn't say that. You have to renew it, and I, for the life of me, can't remember the time span in which you have to renew it. But what I will do is I will get that so Kerwin can get that to you. Is that okay, Kerwin?
That's fine.
And it just escapes me. I'm sorry. My mind is not holding a whole bunch of information. So what is in the forefront of my mind now are the things that I'm specifically dealing with, and I just can't remember, and I don't want to tell you the wrong amount of time.
Okay, no, that's good to know, just kind of upfront, so we can make sure that we start setting that stuff in reserve, you know?
Yeah, you do have to renew it, but it's a long period of time. It's not like every year or so. It's a long period of time.
Okay. And we could, because you had put your contact information, if it's okay, we'll send you kind of what we're working with to start with, and maybe we can email you a photo of the logo.
Absolutely.
And her menu that we have right now, just to get some very high level, surface level opinion on it?
Yeah, absolutely. You'll see there my email address. Feel free to shoot it over to me.
Thank you.
Mm-hmm.
Any other questions?
I think that's all that we have, but
Okay.
again, thank you so much.
Thank you.
Oh, no problem. Thank you.
Yeah. Okay, great, great. And again, I want to thank Marlene for taking the time out this evening to share this this valuable knowledge, because again, we have a lot of youth entrepreneurs that work with us, and many have the same same issue. They come out with logos and different things, and want to make sure that they're protected on the front end, that we don't get caught out there. Like, as you said, that's a great example. Like 10 years from now, trying to fight, for some type of some type of legal matter that's going to be way more than the $200 or $45 that it costs right now to take care of it. Yeah. So, all right. So thank everyone for joining. And again, thank you, Marlene. If you want more information, some questions, reach out to her. Information is on the screen. And I wish everyone a good night. Stay safe. Social distancing.
Absolutely.
All the different terms being shared nowadays.
Yes.
All right. All right.
Awesome.
So
Thank you.
all right. Have a great night.
Y'all stay safe as well.
All right.